Hello friends, Mandar here. I'm back with another video. Today we are going to talk about what has happened with the America's Compete Act in the House. It got actually approved. I also want to make some corrections from my previous video on this particular act regarding the immigration clauses. We'll also talk about one more act that is upcoming which may indirectly affect you, and also some important questions about this upgrade situation when USCIS has posted this alert on having a lot of number of visa numbers available for EB1 and EB2. A lot of people are contemplating whether to upgrade or not, who are already in the downgrade process. So these are very important questions if you are in the process. So watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Now in the last two videos, we talked about America Competes Act of 2022. As you know, this bill was passed in a different version in Senate last year in June. And this was brought in a different version in the House about 2 weeks back. But it got passed yesterday. As I said in my previous video, it had a higher possibility of passing because it had a bipartisan support. Now the immigration clauses in there are still there, the ones that we looked at in my last video regarding the W1 W2 visa, as well as the changes for the PhD candidates of STEM, which proposes to have them visas available without the numerical limits, is also in that bill, which is the House passed bill. Now mind you, this bill still has an uphill battle to pass and go to the president's desk. The reason is because these two versions are very different. The Senate version that was passed against the House version that is passed are very different. So now the Senate is going to form a committee where all these differences are going to be hashed out and negotiated, and they are going to come with some kind of a conclusion or settlement, what can be removed, what can be added, things like that. And this has to be agreed with the House as well. So as long as the final version is created, which is agreed with Senate and the House, then it will go to the president's desk. Now there is some opposition from the Senate Republicans, particularly on some of the aspects of this bill which was passed in the House. And one in particular is the visa carve-out program, which is basically having these unlimited green cards or cap exempt green cards available to PhD candidates. That is something some senators are having problem with. So we'll see in the final version whether these clauses from the immigration are removed or not. Now I also want to make a clarification that in my last video I mentioned that for the doctoral candidates, so there will not be any numerical limits on the immigrant visas that are available for the STEM based PhD candidates, and that was if they qualify for EB1, also EB2. So I forgot to mention EB2, but some people corrected me in the comment section below, so I just wanted to clarify that. So I will just read it out again. In the section 80303 in general, it amends section 201B1 of the INA to exempt from the numerical limitations on immigrant visas aliens who meet the requirements for classification as immigrants under the employment based first preference category or employment based second preference category, which is advanced degree professionals or exceptional ability aliens. They should have earned a doctorate degree in science, technology, engineering or mathematics from a qualified US research institution or foreign institution if the degree is equivalent to the degree issued by the United States. So it doesn't mean that it has to be within the US, your PhD has to be in the US, it can be from outside of the US as well, but it has to be an equivalent degree. So these are the conditions. So I just wanted to kind of clarify because there was some confusion on this aspect. Now somebody also asked that how come there is the word alien left in this, because remember last year when we talked about Biden administration, when they were talking about immigration changes. They said they are going to replace the word alien with non-immigrants or non-citizens specifically, but that apparently has not happened, or even if it has happened, it has not trickled down into these new bills that are getting published. So let's see what happens in the future. So this bill still has an uphill battle to reach the president's desk, but I'm confident that this will reach. Now whether these elements of W and W2 visas as well as this numerical limit exemption for PhD candidates remains in the bill is to be seen. So as and when that happens, I'll make a video on that. Now there was also a question, if anyone has an I-140, EB2 I-140 and is doing a PhD, would they be qualifying for this particular EB1 or EB2 eligibility? I think so, yes. They haven't said that you have to complete your PhD. They said even the PhD candidates who intend to work in this specified field in science, engineering, technology and mathematics can also be eligible for this, will also be eligible for this visa. Numerical limit exemption green card. So it's not going to be a huge difference, because if you consider today, EB1 is already current. So all of these PhD candidates, if they can show all these exceptional abilities, they already qualify for EB1, which is current. So there is literally no wait time. This is just going to make sure that that particular category of candidates will never have to deal with any retrogression. So that's the way I read it. Now somebody also asked me about whether this W visa is similar to EB5 category. I would say it has some similarities, but it is not entirely exactly the same. We looked at the clauses for this W and W2 visas, and I'm not going to go into those details again, but I would say this is kind of a startup visa. So basically, if you are actively participating in a startup, or if you are really a significant part of the startup company build-up, then this visa is for you. There is certain similar visa in Canada and other countries, and I have made a separate video on Canadian startup visa. This seems to have taken an inspiration from that kind of a visa. So I would say this is more like a startup visa than EB2 visa. Now I did not mention this in my previous video about the America Competes Act, but there was a concern regarding impact to people who have invested in crypto. The previous House version of this bill had some language in there that would allow a unilateral authority for the Treasury Department to basically control certain financial transactions. So they could say, okay, this type of financial transaction is valid, this other type of transaction is invalid. So in other words, some of the crypto transactions would have come under scrutiny or outright denied if that language still would have existed in this bill. Now fortunately, because of some lobbying or some pressure put on by some of the institutions, this language was removed from the bill that was actually approved. So all those crypto investors out there, you guys can relax now, because now this bill is not going to be detrimental or impede on your crypto transactions. So you can relax now. Now there is another bill that is brewing in the House and the Senate, which is called Real Courts Rule of Law Act of 2022. So immigration judges have come to the Congress and said that there is a lot of scrutiny because currently the immigration courts are under Department of Justice, which usually is true with all the justice courts that we have in United States. They are all under Department of Justice, now including this immigration courts. Now as we know that immigration courts have a lot of backlog. They have about 1.6 million cases as backlog, where a lot of individuals are stuck in these immigration courts. Now there is an effort underway in the Capitol Hill to remove these immigration courts out of the jurisdiction of Department of Justice. So what that will mean is these immigration courts will have lesser of bureaucracy or lesser of the rules to follow that the DOJ usually imposes upon all of the courts. So they will have lesser things to follow, so that they can be an independent body and move these immigration backlog cases along. It also means that these immigration courts will have somewhat of an autonomy. They will not have to follow the policies and procedures that are pushed upon them by the ruling party, say for instance Democrats or Republicans. So they tend to have an influence on these immigration courts, but having them as an autonomous body outside of the Department of Justice will remove that pressure from the ruling party. So this is kind of good for the immigration courts. There are opinions on both sides of the arguments, so we'll see what happens. I'll be sure to make a video when this bill becomes into law. The reason I'm mentioning about this bill is because it impacts the speed at which these immigration cases are processed. Currently they are crawling because there is huge backlog, and that is partly because of the Department of Justice's imposing of different rules and regulations that have nothing to do with immigration, and removing them from that umbrella will speed up these process apparently. So we'll see what happens. Again, the Republican lawmakers are not so pro for this rule change. They want the Congress to focus on the southern border instead of changing the jurisdiction of immigration courts and removing them from the Department of Justice. So we'll see what happens. Now there are a lot of questions since this USCIS policy alert has come in, and I get tons of questions on my email, and I again emphasize that if you want my attention or if you want my personal opinion in your situation, whether you should upgrade from EB2 to EB3 and things like that, do contact me on my Patreon site, because that is the best way I can give you my full attention to address your question. And again, it is only going to be my personal opinion, what I would do if I were in your shoes, and nothing else. It is not going to be a legal advice. So before you take any action, you should always contact your lawyer and see what they have to say in your particular situation. Now here is a very common question that I have been getting on the Patreon site, and I thought I would cover this in this video. And again, if you need a personal opinion, I'm still there. So here is the situation. In 2020, EB3 was moving very fast. All of a sudden it was spilled over from FB category to EB category, and EB3 started moving very fast. So it actually reached in the filing date chart, it reached 2015, and then it retrogressed. But during that time, a lot of people downgraded their petitions from EB2 to EB3. Now there were certain individuals who did a separate EB3 petition. That was a smart decision, because that way their EB2 was still intact. But others were not so fortunate. Their lawyers probably downgraded the actual EB category from EB2 to EB3. Now as a result of that, there was no EB2 left, but there are still vast majority of people whose downgrade petition is still not approved. Imagine that it's been about 15 to 16 months. These people applied their downgrade petitions in October, November of 2020. They are still not approved. But now the question is, with this new USCIS alert of having a lot more number of visa numbers available in EB2 category, now these people are contemplating upgrading their application back to EB2. Now the question is, if their downgrade petition is still not approved, can they use their previous EB2 to file for an upgrade? My opinion is yes. If your downgrade petition from EB2 to EB3, we are not talking about the separate EB3 petition, we are talking about an actual conversion of EB2 to EB3. If that has not happened, you can interject, you can withdraw that downgrade petition and instead use that previously approved EB2 to file for your EB2 based I-485. And even you can interfile, you can just cancel or withdraw your downgrade petition. You can use your same I-485 and just attach it to your previously approved EB2. That's quite possible. So work with a lawyer on this situation. I think if your downgrade petition is not approved, you have a good chance to just use your EB2 and go back to EB2. Another question, can we have multiple adjustment of status at the same time? Now, there were conflicting answers. Some people reached out to their lawyers, and lawyers were kind of giving them an advice that you should never have concurrent I-485s. My personal opinion is, yes, you can have. There is no problem, because technically nobody is preventing you from applying for multiple I-485. So here's the thing, green card is always for future employment. Now if you are in demand candidate, if you have certain skills that a lot of companies want to have from you, so there may be 2 or 3 companies who would want to hire you after you get your green card. Consider this. So each of them may file an independent green card application for you, and each of them, through those applications, you might have multiple I-485 applications pending at the same time. It's quite possible. Another scenario is if you are stuck in the backlog, you might consider applying through a family based category at the same time. A brother or a sister who is able to sponsor you, and while your employment based petition is pending, you could also apply for family based petition. So you could have another 485 at the same time. And here's another thing, if you have saved enough money, you could also self petition for EB5. Nothing stopping you from doing that either. So now you have EB petition, EB2 petition or EB3 petition, you have family based petition, you have EB5 petition. Now, word of caution, not everything is black and white. When the petition, one of these petitions reaches a certain stage where a visa officer is now looking at it, they will consider, okay, are you really going to move forward with EB5 or family based application or an employment based application? At that time, they will either ask you to withdraw the other two applications and go forward with one single application, or they will deny your other applications and only process the ones that they think is the most further along in the process. But most probably they will come back to you and ask you to withdraw the other two petitions. So this is my opinion. When you have multiple 485s, consult with your lawyer with whether that's a good idea or not. At the end of the day, these are all parallel ones, and you will probably have to withdraw one of them and proceed with the other one. So really, that's all I wanted to talk on this video. I'm also working on some of the other topic videos such as tax returns, and also a video on how to bring your own money from India to United States and how to go through the tax hoops. So if you haven't subscribed to my channel, do subscribe, hit the like and bell notification, and I'll see you in the next one.